Hi students, let's start with a new landmark case, and this time the case is Maneka Gandhi versus Union of India, and this case has many highlights. This was a case where the golden triangle principle was established for the first time, and this Maneka Gandhi versus Union of India is also called as personal liberty case and passport case. We will discuss this case in detail. First, let's discuss the basic details about the case. Like the case name is Maneka Gandhi versus Union of India, and of course the petitioner is Maneka Gandhi, respondent is Union of India and others. And the judgment of this landmark case passed on January 25th, 1978, and this judgment has passed. The case was considered by a 7-bench judge of the court. So we will discuss each aspects in detail. So let's see what was the background of the case. After the declaration of emergency, the Congress party had lost its general election held on 1977, and then the Janata Party came into power. And we all know that Maneka Gandhi, the petitioner, was Indira Gandhi's daughter-in-law, and she was running a magazine called Surya Magazine, and she was supposed to travel abroad to deliver a speech on democratic and human rights, but her passport was impounded or seized by the passport authorities, and as a result, she was not allowed to fly abroad. So let's cross-check what were the facts of the case. Here in this case, the Maneka Gandhi, the petitioner, was issued with a passport on 1976. But in 1977, she was asked to surrender the passport by the regional passport officer, New Delhi. And the Ministry of External Affairs didn't produce any reason why she was supposed to surrender her passport. They just quoted it was for the interest of the general public. So the petitioner approached the Supreme Court under Article 32 jurisdiction, alleging that the act of the state which impounded her passport is a violation of Article 14, 19 and 21 of the Indian Constitution. The petitioner also made attention of the judgment passed in Satwant Singh case, in which the Supreme Court held that the right to travel abroad comes under the ambit of Article 21. The petitioner also alleges that the Section 10 Clause C is a Clause C of the Passport Act 1967 is ultra vires. Let's see what were the issues raised before the court. First, the petitioner raised that whether the fundamental rights are absolute one or a conditional one, and whether the right to travel abroad is protected under Article 21. The second issue raised was, is there any connection between the rights guaranteed under Article 14, 19 and 21 of the Constitutional Law? Then the next issue was, what is the exact scope of procedures established by law? Then the fourth one was whether Section 10 Clause 3 Subclause C of the Passport Act 1967 is actually violating the fundamental rights. And the last one was whether the imposed order of the regional passport officer is in contravention of principles of natural justice, or is it against the principle of natural justice? And the statutes and provisions discussed in this landmark case was Article 14, 19 and 21 of the Constitution of India and Section 10, Clause 3, Subclause C of the Passport Act 1967. So let's see what were the arguments from the petitioner side. Maneka Gandhi argued that the administrative action of the state to seize her passport was an infringement against her fundamental rights granted under Article 14, 19 and 21. And she also argued that these three articles should read together, and because they are interconnected, then only if we interpret these three articles together, then only we could realize the true spirit behind the constitutionalism, and we can uphold the principle of natural justice. She also argued that the due process of law was an American concept, and we Indian Constitution adopted the procedures established by law, which is a British concept. And according to these procedures established by law, it says that a law, when it gets enacted, it should be just, fair, reasonable, and not arbitrary. The petitioner also argued that Section 10, Clause 3, Subclause C of the Passport Act 1967 violates her right to life and liberty, which granted under Article 21, because it restrained her from traveling abroad. And the maxim, Audi Alteram Partem, was denied to her, which was the basic principle of natural justice. And the petitioner also contended that the judiciary should go for a judicial review on the imputed administrative action and law. She also pointed out that right of free movement across the border is a globally recognized right, and there was a clear violation of the international human rights law standards. So now let's check what were the counter arguments from the respondent side. The respondent said that the petitioner's passport was seized because she was supposed to appear before a government committee for hearing. And then they said, or they argued, that the word law under the article should read in accordance with the principles laid down in AK Gopalan's case, in which the Supreme Court has observed that since we followed the procedures established by law, there is no necessity of the test of reasonability. And there was a long debate in the Constitution Assembly regarding the American concept, due process of law, and the British concept, procedures established by law. And finally, we adopted the British concept. So, the intention of the framers of the Constitution is really clear, that each provision should interpret according to the words mentioned in the provisions, not to look into the spirit behind each provision. Then the respondents argued that the right to travel abroad, never it comes under Article 19 of the Constitution, because Article 19 is an independent one. And they also argued that the Passport Act 1967 was not enacted arbitrarily, and it not violating any fundamental rights. And they also argued that yes, it was for the public good and national safety. The government has decided to seize the petitioner's passport, and so the government is not supposed to mention any reason why being seized. And they also argued that the principle natural justice, it's a vague concept. So the provisions of the Constitution should not need to interpret in accordance with the concept natural justice. And they concluded their argument that seizing a person's passport is absolutely a discretionary power of an executive, and the same incident happened because it was a necessity at that time. Now we will see what the seven-bench judge of the Supreme Court decided, or what was the judgment. This important judgment was delivered on 25th January 1978, and we can say that this actually absolutely changed the Indian Constitution, or the face of the Indian Constitution. The judgment also proclaimed that yes, India is a welfare state as mentioned in the preamble, and the main significance or the main highlight of the judgment is that it widely interpret the scope of Article 21, and even though there were 7 judges in the bench, the judgment was made unanimous. The court remarked that before enacting the Passport Act 1967, there was no any law to regulate this issue of passport. And if a person wanted to leave his native place or want to settle abroad, it was an absolute discretionary power of the executive to decide whether the passport is to be issued, and if they issued it, it was on the basis of unguided and unchallenged manner. And later in Satwant Singh Sanghvi's case, the Supreme Court held that yes, the right of locomotion and the right to travel abroad all comes under the ambit of Article 21. And the Act of the Passport Authorities under Section 10 Clause 3 Subclause C of the Passport Act is not unconstitutional because yes, the Passport Authority has the power to grant, suspend and cancel the passport if it is related with national security. But the court has observed that what happened in this case is that the Maneka Gandhi was not given any opportunity of being heard, and she was not produced with any valid reason why her passport was seized. So her argument that it is a violation of Article 21 is a substantial one. And moreover, the court also observed that here in this case, the central government did not disclose any reason why the passport has impounded. And they just quoted that yes, it was seized. The passport was seized just because to protect the interest of the general public. But the court made a remark that from the facts, it's clear that there was no any threat to the national sovereignty or interest of the general public. The central government just wanted to make her appear before the inquiry commission. That was the intention behind seizing the passport. The court also observed that the basic ingredient of the principle natural justice, which the maxim enclosed like Audi Alteram Partem, was clearly denied to her, and the court also observed that the fundamental rights granted under Article 14, 19, 21 are not separate, they are interconnected because it is already established that if there is a violation of Article 21, automatically the rights vested in Article 14 and 19 also get affected. Thus, for the very first time in this landmark case, the Supreme Court has established the Golden Triangle Principle. And the court also held that since we are following the procedures established by law, the reasonableness is very much necessary. The law enacted should be fair, reasonable, and should be free from arbitrariness. The judgment passed in AK Gopalan's case was overruled by this court through this judgment, and it clearly held that yes, there is relation between Article 14, 19 and 21 when we interpret these articles together to find out the actual spirit behind all these articles. The Now let's see what was the rationale behind this judgment. In this case, the court interpreted Article 21 in a wider way so that it could give a new face to the Part 3 of the Constitution, which deals with the fundamental rights. And the court believes that yes, it's very necessary to restore the people's faith in the judiciary and to uphold the constitutional values. And the court also established that yes, India is a welfare state as ensured in our preamble. And the principle of golden triangle will always declare the judiciary as a watchdog of the democracy. Actually, it was before this landmark case, Article 21 was granted against the action or arbitrary action of the executive only. But after this judgment, the protection of Article 21 was granted against the legislative too. And the court also observed that the maxim Audi Alteram Partem means to be heard. It's a principle of natural justice and it should not get infringed at any cost. And by overruling the judgment in AK Gopalan's case, the court tried to explain that while interpreting a law or a provision, the court should try to find out the inner meaning from the words or from the lines of the provisions to find out the actual spirit of the Constitution. So we can conclude this case law that by this landmark case, a new interpretation was given to the fundamental rights granted or guaranteed under Article 3, Part 3 of the Constitution. And yes, a wider interpretation of Article 21 is very much needed to keep India as a welfare state. And the another harmonizing tool, the concept of post-decisional hearing. It was also developed by this landmark case. And what is exactly this post-decisional hearing means that an individual will be given an opportunity to be heard after a tentative decision has been taken by the authorities. In this case also, even though the Maneka Gandhi's passport was seized and they didn't produce any reason, just quoted that it was against the interest of general public. Even after all this impugned action, she was again given another chance of this by this concept, the post-decisional hearing.